Some 30 experts from Asia, Africa, the United States, and Europe exchanged views at a seminar co-organized by Leiden University's Croce Center for International Legal Studies and Wuhan University's Institute for Boundary and Ocean Studies. Around the arbitration unilaterally initiated by the Philippines, a wide range of issues were brought up at the seminar about the appointment of arbitrators, the arbitral proceedings, and the controversial jurisdiction. Fu Kunchen, Dean of the South China Sea Institute of Xiamen University, voiced his support for China's stance, saying China's not participating in the arbitration tribunal is something very positive.
Because in UNCLOS Part 15, Section 3 has clearly manifested its intention, which is to exclude, be exceptional to Section 2. In this case, Article 298 has provided for that any disputes concerning interpretation or practice of the Convention relating to any one of the following four factors should be excluded, its jurisdiction should be excluded. One is maritime boundary delimitation. Here, it's involved, it's related. Two is historic title. Here, again, it's concerned. Thirdly, is something concerning territorial sovereignty. Again, in this arbitrational procedure, it's related. And fourthly, up to now, it's not related here, it's a military confrontation.
Fu said by insisting not to participate in this illegal arbitrational procedure, China has helped the world to sustain dignity and predictability of the clauses and articles of UNCLOS. By insisting not to participate from the very beginning and not to accept any of the result will help the world community to establish the rule of law itself. Srinivasa Rao Pamaraju, former chairman of the UN International Law Commission, says that no matter what the result of the case might be, it would not help its tensions in the disputed waters, as the ruling would only be an abstract academic exercise without true value in resolving disputes.
I think one has to be patient in these matters. It would have been, and in any case, the arbitration which is now looking into the matter at The Hague is not going to deal with the sovereignty issues. It's only dealing with some small islands, rocks, and other features, whether they can generate, in an academic sense of the term, certain maritime zones, 200 miles, 12 miles, like that. That is an issue which is almost like an academic issue, whether can a rock produce 200 miles or not, whether this is a rock or not. If this is a rock, can we sit on it or not? If we can sit on it, and under what conditions can I say this is my property, not somebody else? And if it is mine, to what extent can I use it, under what circumstances? All these are all academic questions. But the real thing is, there is a history, there is a procedure, there is a methodology, and there is certain evidence that has to be really gathered and presented to each other.
Experts say the Hague-based arbitration tribunal's rule of its own jurisdiction over the case will broadly undermine the potential utility of international adjudication. The experts also called on international communities to adopt a correct, comprehensive, and integral interpretation of UN conventions on the law of the sea, and also urging different parties to resolve disputes through effective and reasonable dialogues. CCTV, Hague, Holland.